All right, Milan, let's go ahead and get started. Welcome everybody to our first joint webinar that Milan and I have done. My name is James Monroe. I'm a financial advisor and financial planner here at Oregon Pacific Financial Advisors. Milan's a good friend of mine. He's an estate attorney that's up the street from us. Milan, say hi.
Hello, everyone.
Milan has graced us with helping us out as his business and my business constantly cross paths, and we're able to help each other and help each other's clients and really give some education. So our goal tonight is to give you some education and offer you some benefits for joining us tonight in the webinar and being able to have some consultations with us and things like that, if that's what you guys decide to do. Just so you know, if you guys have any questions during the process, if it's a question that you don't want everybody to see, if you could please in the chat, just message the host, which is myself. I'll help field some of those questions for Milan as we take breaks and kind of go through the process, and we'll go ahead and get started. I'm going to go ahead and get started with my portion of 5 reasons to plan your finances. Milan's going to follow up with estate planning, which I think is just as urgently important as planning your finances, because having stuff taken care of is probably one of the biggest gifts that you can give your family when that time comes. What is planning? When you look at the word planning, I look at it as it's exactly that. It's exactly the question. You have to plan. You have to be rigid in your outcome, but you really need to be flexible on your approach, because life's going to throw you curveballs. Life's going to change stuff. You're going to lose a job. You're going to get a better job. You're going to have an unexpected child. You're going to have things happen with your house. There's going to be a fire, especially like here in the valley. It just happened recently. Things happen. So you have to be flexible in your approach. But at the end goal, planning overall, whether it's financial planning or estate planning, is very important to be rigid in what your outcome is. So step number one, I believe in, sort of the 5 reasons to plan that I look at is number one, to become financially literate. I do a monthly webinar series on the first Thursday of the month, and it's really just a 20,000 foot view of financial literacy. One of my goals and one of the reasons why I love what I do for the last 15 years is just that. It's teaching people the basics of finance. It's teaching people how to do that. First you need to have a firm understanding of your own personal finances, and then set achievable goals and benchmarks that you can constantly track. I'll talk about my past life is what I call it. I was a personal trainer, and we always had goals. We always had measurements that we took. And then working hard and learning with someone that could teach you without, having a bias of things. Number 2 is to have a roadmap to meet your goals. My family and I were going to Sun River this weekend for a little vacation, a little 3-day vacation. And with all the weather and with all the things going on with, the snow and ice and freezing and all that stuff, we're going to have a GPS on to help us get there and help us get there safely, right? We're going to have that. Most people don't have a great financial plan or a roadmap or a GPS on how to get to where they want to go. And they're like the slide says, there's many detours that happen that, it's a big important piece of the puzzle. And again, taking ownership, being accountable, having somebody that you can work with, that you trust to help you, whether it's maximizing your 401k, or whether it's getting out of student loan debt, or whether it's purchasing your first home and planning to get rid of that credit card debt, planning those finances, and all of that moving forward. The third thing, and I think one of the most important things, is that you have to understand that your financial health doesn't happen overnight. Understanding that you're playing the long game, understanding there's a process. Like I mentioned, in my previous career, I owned a personal training company, and very similar to the physical health, you have to have a long-term goal where you're really monitoring different things, like your spending patterns. Like when your cash flow increases, what does your spending do? Investing wisely with guidance, growing your capital, eliminating debt, getting out of debt. What does your credit score mean? How do you get out of that? How do you work with that? Working with people that you trust, that you can work through, is just like having a great personal trainer where they can help you reach your goals and make measurable stuff that will help you get sort of to that point. Step number 4, begin saving for a rainy day. So there was a survey done from a company called bankrate.com. Bankrate.com said that 61% of American households, I'll repeat it again, 61% of American households have less than $1,000 saved. So here's what I know, and here's what I've learned in my 15-year career in this industry. There's going to be an emergency, and that emergency is going to cost money. I don't know how much money it'll cost. But if your tire blows on your vehicle, you have to go pay for the tire. So most people will use a credit card to pay for that tire versus using cash because, like this survey said, 61% of the people don't have money saved for a rainy day. And we don't know when it's going to happen. We don't know how much it's going to cost. But, for the what ifs in life. My wife, a few months ago, she had a kidney stone. And that kidney stone was 9 millimeters, and she had to go to the doctor, and she had to get that kidney stone broken up, and that cost us money. We have a deductible that we have to hit, so that cost us money out of our pocket. But because we've been diligent about saving for a rainy day and about having that and practicing what we preach, we were able to not put that on a credit card and make sure that we had that liquid cash available. And one of the things that I love doing is helping people realize that it's not that difficult, and you too can do it. So the 5th one, talking about, really reducing money-related stresses. And this is probably the one that I'm going to spend the most time on. So sometimes debt's necessary, but sometimes it's not. With most people, if you're going to buy a home, most of the time you have to get a mortgage. That debt's sort of a necessary thing if you want to purchase that home. But when you get into your retirement years, when you get into the years where you're making less money or you're not working anymore, you want to have those debts paid off. Having a personal and mental well-being is a big deal. Having that stuff so that things are in place for you and your family, so it's a peace of mind. But having that mental well-being, pre-planning everything. We pre-planned for this trip. We've saved for this trip. We've done the things necessary to be able to do that. Adequate insurance coverages. I was sitting down with a client last week and kind of going over their insurance coverages. And, I'm not a property and casualty insurance person, but I was able to look at their auto insurance and their homeowner's insurance, and they have a rental property, and realize that they're sort of underinsured. So luckily for me, I have a team of people around me that do some of those other businesses that are sort of peripheral to my business, like the auto and homeowners insurance. And I was able to go to them and go, hey, what would you do if this was your sister? And they kind of gave me a bullet point list of here's where she's underinsured, or here's where she's insured in a different way that she should be, in our opinion. And I was able to help her and guide her to the right person to be able to talk to. Health insurance. Health insurance is a big deal. I was talking to some clients the other day that they're getting ready to retire, but one of their major worries is that health insurance costs are going to be too expensive, and they're only 62, but they don't get Medicare till 65. So again, working with people that I'm close to, that I trust, and having the ability to be able to talk to them and go, hey, is there a way that we could do this and not cost them an arm and a leg for their health insurance, and able to really direct them again in the right way. The 3rd insurance that I always talk about is life insurance. Life insurance is a big deal. Being in the industry for 15 years, and not all my clients, but family members of clients or friends that have somebody pass away, helping somebody walk through the process of what happens when you pass away, and not necessarily from the estate planning side of stuff, because Milan's going to talk a lot about that, but from the standpoint of there's stuff that you have to do. There's stuff that you have to accomplish when somebody passes away. There's Social Security that you have to deal with. There's insurance companies and assets and IRAs and retirement plans and things like that you may have to deal with. There's the house, there's there's stuff, and having somebody that isn't emotionally attached to be able to help walk through that process is a big deal. So in 15 years, I've helped, I'm now working on my 21st family that I'm helping walk through that. Number 4, one of the biggest insurances that I think are overlooked is something called long-term care insurance. Here's what long-term care insurance means. You can no longer do 2 out of the 6 activities of daily living, which means bathing, eating, getting out of bed, walking, going to the restroom by yourself, things like that, and you need help. Well, there's sort of 3 ways that you could pay for that. You could pay for that out of your assets. You can pay for that out of your savings. But eventually that savings is going to go down to zero. And I'll tell you, from firsthand experience and from knowing people, long-term care cover or long-term care isn't inexpensive. It's expensive. You can have the state take care of you, but with that process, you have to draw down assets. There's rules that you have to follow. And I don't know how anybody else on the webinar tonight feels, but my opinion is that the state is going to do the bare minimum that they have to do to help you, or you could purchase what's called a long-term care policy and have that covered so that financially you're covered, so you don't have to draw down your assets, so you don't have to do that. So that's one of the ones that's pretty grossly overlooked. And then the 5th one, and it's really important here in Oregon, because in Oregon we don't have a state disability insurance. So if you're still a working professional and you're under 65 years old, I always recommend that you take a look at some sort of a short-term disability insurance coverage, because what happens if you break your leg? What happens if you get in a car accident? Who pays your bills? Who does that for you? Well, there's insurance stuff that you could do that would help you along the way and help you be able to pay your bills and pick up some of that stuff. Planning early can help you prevent stress that can make you physically unwell, that can make you mentally unwell. And stress, being a personal trainer for as long as I was, stress does have a direct link with your physical well-being and your ability to be able to fight disease and your ability to increase your immune system, good, bad, or indifferent. So with all of that said, the next question is, well, where do you sort of go from here on the planning side of stuff? What do you do? Now, people can do it themselves, and Milan will shake his head no when I say this, but and I don't recommend it, but there's do-it-yourself estate planning online too that you could do. But it's not the best idea because you're not sort of the expert in the estate planning or the financial planning side of stuff, but you could do it yourself. You could work with others in the area. You could work with others that you trust that, honestly, between Milan and myself, I know that we both feel like we give the best service around, definitely. And which leads us to the 3rd one, where we'd like you to work with us, right? Or you could do sort of that last one, which is what I call the biggest nation in the world, which is called procrastination. So planning is very, very simple. And pre-planning stuff and pre-planning your trip and pre-planning that course to retirement on the financial side of stuff and making sure you have the proper things set in place and all that stuff while you're alive is very, very, very important. The next thing that we're going to talk about is estate planning. And Milan is not only a good friend of mine, I consider him a friend for the last 2.5 years, but Milan is my personal estate attorney. He's the gentleman that helped me set up my trust and my estate. So I trust him with my own family. I trust to make sure that, our stuff is taken care of properly, which I'm really, really excited for him to get into his portion, which is, really in my normal presentations is step 6 is leaving that legacy and is having that estate plan set up properly. So for my time, I want to thank you guys for attending tonight. Thank you guys for your time. Milan, I'm going to allow you to go ahead and take it away, and I'll help field some of the questions and that stuff, and stop you along the way if we need to as you go through your part of the presentation. But thank you so much for your time tonight too, Milan, and go ahead. The floor is yours.
Great. Thanks, James. And just another little recap about what James was saying. I mean, I've worked a lot with James, and I actually learn a lot from him. And there's so many pieces to the puzzle of our own finances, what's going to happen to them, what's going to happen to our business. And not any one of us have all the answers. And I always am reaching out, getting educated. And even James has been a wonderful source to teach me a few things, because I talk to clients just on a few little things. Everybody else has got a different set of eyes on the problem, And sometimes we might not even realize it and have a false sense of confidence when we try to do things ourselves. So here, I'm going to talk about family wealth preservation planning. Most people call this estate planning, but really, this is taking back and looking at maybe from a bigger picture. Really, what do we have to pass on? So I have a question. Why did everybody come here today? You're taking your valuable time to probably sit here, and some people might not be interested. And so maybe did you come because you want to have total assurance and comfort of knowing your family would be taken care of and that they would know what to do if something happened to you? Did you come for peace of mind to know what would happen to your assets at your death? Did you come to find out how to make sure your family doesn't pay estate taxes unnecessarily? Or maybe you came just to make sure you'd be taken care of in the best way possible and the best decisions would be made for you if you became incapacitated. If you came for any of those reasons, then you came for the right reasons, because today you're going to learn a little bit about what you need to do to have the peace of mind of knowing that you've made the right decisions for your family during your lifetime, so that at your death, things are as easy as possible for the people you love the most. So, when was the last time you reviewed your existing plan? If anybody even has a plan out there. Or if you don't have a plan, then what is the plan for you right now? Do you know what would happen if any of you passed away? So if some people are averted for this, they say, hey, I don't want to be thinking about my own death. What would we, and even if they do, sometimes it's a one-time transaction. You just get some form documents. Hey, you maybe put them up on the shelf and say, hey, I did that. I think I acted like an adult. Okay, good. Maybe you're trying to avoid probate. Maybe you're trying to get around estate taxes, or you're going to be leaving assets to your heirs unprotected. But a lot of people don't go back and talk with their attorneys about updating their plans, or their situations change and they aren't necessarily getting the advice they need on what is going to happen with this new scenario. And maybe there's a potential loss of your assets to the State Department of unclaimed property. And the bigger question is will your plan work when your family needs it? So I've had a client that her father had just married a much younger lady. So she had a new stepmom, and I'm sure her stepmom was a wonderful person and they welcomed her into the family. But her father knew that there would be issues between her stepmom and the rest of the family. And so this is probably back in the 90s, and her dad went out and hired an attorney for $3,000, which is a lot of money, especially back in the 90s. And he did everything he thought. He had got back these big binders from the attorney, put them up on the shelf and said, you know what, I think I've done enough to protect you guys. I hired what I thought was the best attorneys around. But sure enough, when he passed away, and he had a typical trust, and that trust was not funded. The attorneys did not fund the trust, and everything that her father had ended up going through probate in order to be put in the trust. But in order to do that, it actually ended up in a big family conflict with the new wife trying to take a lot of those assets. It didn't go as planned because it wasn't executed as it was planned. And this client, she said, well, is this legal malpractice? And I'd say, you know what, I've talked to a lot of the attorneys around here, and it's not. It is not. As long as the attorney has provided the documents and provided the plan, they've done their piece of the puzzle. But so often that is still not enough to keep your family out of court and out of conflict. So I want to say this got me thinking about new ways to make the estate planning process better. So instead of planning for death, I like to think about it as planning for life. And so I'm taking extra time in what I call these family wealth planning sessions just to educate my clients. Sometimes they're going to come into the attorney and they say, hey, I know what I want. I want a will, everything to this person. And they don't want to talk. They don't want to like maybe problem solve and think about, well, how do we do that? There's going to be a lot of do-it-yourself forms that kind of just do that. You type in just what you say you want, but you haven't thought about the consequences of what that's going to mean on the back end. Because so often, a lot of these plans, you and I aren't going to, I mean, you probably aren't going to be experiencing whatever can go wrong with them, because it's going to happen when you pass away. You won't understand the legal time bomb, like ticking time bomb that's going to be there until after you're gone away. It's not necessarily your problem, but it's so hard for me as an attorney to talk with a family that's already grieving. They've lost somebody, and then I have to tell them even more bad news. Well, it looks like there are some issues with the way the trust was set up. There's issues over here. So, and all that just to prevent a lot of the problems that I see. We won't try to save your family thousands of dollars, especially by making bulletproof strategies to avoid probate. And then not losing your assets at your death. So often a person, like a child, will come into me, my father's passed away, my mother's passed away. They said I'm an executor or I'm in charge of their estate. And I say, okay, great, let's get to work. And they say, well, what do we have to do? And I said, well, what did your mother or father own? They said, I don't know. I know they have a house. Well, what else is there? And so often we spend months and months of our time trying to hunt down and track down and be like a personal investigator to try to figure out what the parents actually owned and what they had. And even towards the end of doing an estate, we don't know what we haven't found. And I'm going to talk a little bit about more about that later. And then so often we try to protect our family's money from outsiders. Sometimes creditors and other people can get involved. A lifetime of the right legal and financial choices. And then this is something that I have been encouraging people that even if we ever do an estate plan, please have it reviewed. We want to make sure that your assets are still in the trust, because you're going to be alive and you're going to be buying and selling property. In each of those changes, we want to make sure that it's still in the trust and that your family knows where it is. So in case something happens. So here, this is a little bit about what the probate process looks like. You probably maybe have heard it. What is probate? Oh, we're trying to avoid it. What is it? So I like this quote here, right at the bottom here. A lawsuit you file against yourself with your own money for the benefit of your creditors. When you pass away, everything that is in your name is going to go through probate. And this is where the court has to appoint somebody as an executor. Sometimes here in Oregon, we call them a personal representative. And they're basically kind of like a glorified accountant. What they're going to be doing is getting all of your assets, maybe your house, your bank accounts, your stock accounts, your retirement accounts, and start to kind of clean those out and put them into one estate bank account. And then from there, so we marshal all the assets. We get everything. We kind of put all the eggs in one basket. Then we know how much you have, your net worth, what you were, all your assets and everything. Finally, we've sold it off, turned it into money. And then from there, we also have to find all your creditors. So to wrap up your affairs, we get all of your money and then we pay off all of your debts. And then finally, at the end, your children, if they're going to receive your inheritance, the legal word for it is actually called residue. It means whatever's left over, because as you see kind of coming through this little pipe here, what's left over because everybody else has a priority to the money over your children. They get what's left. So there's going to be the attorney's fees. The attorney's fees are going to come out of it. Basically, if you pass away, you're paying for your probate attorney, and that's eating out from your kid's estate. So there's going to be the executor's fees or the personal representative. They can take a little for doing this job. They can take a little extra. Even if they're going to inherit some money with their brothers and sisters, they can still take a little extra just to do this kind of work. And then there's going to be appraiser's fees. We got to value what you have and then probably get it sold. Sometimes there's realtor fees. There's going to be transfer fees when we're transferring stocks. There's going to be filing fees in the courts. And then anybody else, creditors. We're going to pay off all the creditors, all mortgage, anybody you had a debt with. And then there's sometimes, because this executor is it's such an important job. You could imagine if you were managing maybe your parents' estate, or somebody was managing yours, and maybe you had maybe $500,000. It's easy to even see some person with modest amount of money. They have a house. $500,000 is not unheard of for an estate. They may not have thought of themselves as being $500,000 rich, but the kids, when they're holding on to, suddenly, they could have been working some job, but to hold on to $500,000 in trust, because they got to pay out their brothers and sisters, the court requires them to pay a bond. Actually, if you have a will, we could get rid of the bond. But this is just a little bit of this process, and it can take 6 to 12 months. I mean, realistically, it's probably 12 or more. I've kept these things open, probates open, for 2 to 3 years. The court does want to kind of like wrap it up, but it's not unheard of. And so that these things are open for at least a year, because your parents pass away, you're not immediately getting a check. This is the process that you have to go through in order to do it. And it can be long and slow. And another one of my clients, he came in, he was actually buying a house from someone, and they passed away recently. And right before they sold him the house, and he says, well, I still want the house. And I said, well, there's no person to be able to sell you the house anymore to sign the documents. The executor of the estate can sign the documents and get the house sold. And I said, well, great. Do the kids want to open up the estate? And they said, no. I said, well, good, you can do it. But he was surprised. He was just trying to buy a house, and the seller passed away, and I had to explain this process to him, and he was very surprised that it would take this long possibly to go through to finish his house sale. So, and even then, if you just have a will and you're going to go through probate, in fact, there's a default set of rules. If you have a will, you're going to go through probate. That's where you have more control of the process, because you can actually say, this is who I want to be my executor. This is how I want it to be distributed. But even if you don't have a will, you're still going to go through probate. It's just more people can apply to be your executor, and it's probably going to pass by what we call intestacy laws, and usually that's pretty much to your family, your closest to kin. If you have a spouse, it's going to go right to them. There's actually special issues for families that are mixed. If you're on a second marriage, or your partner or somebody else that has children from another relationship, it's probably very important to get some estate planning done. But I just wanted to show this. This is the will of Jackie Kennedy Onassis. And here you can just read it. It's on the internet. Anybody can, because this probate process is absolutely public. So you can get in here and read exactly what she gave to who, and sometimes in how much. And if you wanted to know, we know exactly how much went through probate. And I think it was, she had maybe like 68 million at the time. But there was a lot of charities that she included that actually didn't go outright to the charities that she wanted to benefit, because she didn't have her will updated. But that's another issue. But this is a completely open and public process. And in fact, I'm also find that when we file for probate, creditors are actually sitting there watching the court filings, and they're saying, oh, does that person owe me money? Oh, does that person owe me money? I find that even before we've done anything, even in probate, we actually have to put a publication out in a newspaper, which costs about $400, to show, hey, creditors, If this person owes you any money, come get it now. But here, this process is very open. So in here, part of the probate process, because it wants to wrap up usually in about a year, if your children are minors, could you imagine if you were going to be getting what, $50,000, 50,000 in 1 year, and maybe you were 18? If your kids are under 18 and you pass away and they were going to get an inheritance, the person that was going to take care of them would actually have to apply for what's called a guardianship conservatorship of them. And that conservator would have to hold the money for them and could use it only for a certain amount of expenses. And this was probably because back in the day that there was probably some childhood movie stars that, had probably made millions of dollars when they were kids. And then when they finally turned 18, they said, Mom and Dad, hey, where's my money? And they said, oh, Junior, don't you remember those nice trips we took? Those nice hotels we stayed at? And the parents spent the money. So in order for a kid to receive an inheritance, they can't hold the money. If their parents have passed away, it's like in even getting a guardianship, a conservatorship can cost an extra $2,000 just to be able to do this. But if the kid turns 18, there's nothing stopping the kid from getting an outright distribution. So I've had other clients that basically they did get, say, a considerable amount of money right when they were 18, hundreds of thousands of dollars, didn't go to college and pissed it away. Within 2-3 years, there was nothing left of it. Didn't buy a house, didn't invest it, didn't do anything. And sometimes because they have money very, very early on, and they can be all this confidence and these hormones are still raging, and sometimes they get married. They get married to whatever what, James, you're married to your high school sweetheart? Not your high school one? Okay. A couple people I know, and it's turned out really good. But in this case, this person did inherit a lot of money very early on. They got married very early on, and even while the money was holding out, they had a great time. But as soon as the money ran out in about 2-3 years, they got divorced, and there was little or nothing to show. Their relationships were hindered, and there was nothing to show. This person that finally, by the time they did finally go back to school, and they by 30, they said like, oh man, I kind of wish I'd never gotten that money because it maybe set me back. It maybe set me back years. It gave me like an excuse not to kind of get up off my butt and go do something more productive. So here, sometimes if your money is left outright to your kids, unprotected, this can cause another big problem. And this is another reason why just outright or through a probate process or leaving money outright to kids is not always the best idea. So even if your kids could be at risk, even if you have a will. So I talked a little bit about the guardianships and conservatorships. So 69% of parents have not named any guardians for their kids. And this would be, in here, I have a story about a Barber family. They were a couple. They were, I think, living in Arizona and driving to California, and they got in a car wreck. Their kids were at home back in Arizona, and they both passed away. And there was a sister back in Arizona that immediately took the kids. And there was another, her parents, I think it was the wife's parents, and maybe the husband's sister got in a fight over who would take the kids. And they spent probably around $50,000 in attorney's fees just fighting over who would get the kids because it wasn't named. So I've had some other clients. It was just I don't have kids. I have this girlfriend, and so it feels like I've just inherited 3 children. And so my learning curve has kind of gone up. And oh my goodness. Well, it's another story. But already right now, and I can't depend on the kids' fathers. I am stepping into that role. But even right now, if something was to happen to me and my girlfriend, and the kids were at home, and we don't have any other family, around in the state, what would happen to him? So even for me, I'm not even legally entitled as not being a biological father. If I would say, if my girlfriend passed away and I said, I want to take these kids, I'm not named as a guardian or anything on them. I wouldn't have any legal right to be able to take those kids. So naming, even if those kids loved me, wanted to stay with me, and I was basically kind of their surrogate father, if it's not named, if I'm not named as a guardian, it's not going to happen. There's so many other people that would probably have prior rights to me. But with that, naming your kids in your will sometimes is your kids' guardians in a will is not enough, because the will only becomes effective when you pass away. So even if you were just to get in a car accident and you were maybe injured, couldn't do anything, couldn't watch the kids for even 6 months, your kids might not be returned to you. They could be, the authorities would have to do something. They might find a court-appointed authority to do something, to take care of the kids in the absence. So there's a couple issues with how we're going to be naming guardians and conservators of our minor children. And then, I'm not sure if anybody here has heard the story of Terry Schiavo. So this is a little bit before, I think this is like the 90s. And this was a little bit at the time where America was starting to wake up to this idea that we need what's called healthcare directives or advanced directives. And these are instructions for our doctors on end of life care. And without it, the doctors, they have this thing called the Hippocratic Oath, they have to do everything possible under the sun to keep you resuscitated and alive. And so with Terry Schiavo, she, I believe, got into an accident. She became incapacitated, and it was even her husband and her parents got into a legal battle. The doctors basically said that she was going to be perpetually in a vegetative state, and there was no chance of her waking up. And I believe she was in that state. It was over a decade. She was just living on life support in the hospital, and the state was paying for it. Her husband said, well, I want to pull the plug. Her parents said, nope, if there's any chance, maybe one day she's going to wake up. And still a big legal battle, tens of thousands of dollars spent on attorneys just trying to figure out what to do. And this is maybe one of the worst stories I had to. That was just one example, but I have had so often. I've had elderly clients that come in, and we've worked on their advanced care directives together. And I've done an updated version that kind of is for COVID, because we put in there, hey, COVID, please do leave on lung resuscitators. I mean, there is so air respirators. That's been the big thing. Even if everything else kind of goes bad, even with COVID, you can, with an air respirator, there's still pretty good likelihood of you coming back. We've just updated our advanced directives in that way. It's always kind of evolving. It's always changing. And what I do for this with my clients is we take these advanced directives and keep them on file with the local hospitals. So that's Providence and Asante. So if anything in an emergency, it's already there. The doctors know what to do, because if you don't have an advanced directive, the doctor's hands are tied. It's not their decision. They have to keep you alive no matter what, regardless of the cost and regardless of the agony for your family. So now we've kind of talked about common planning techniques that don't work. And here, I have a lot of clients that come in, well, can't we just own everything jointly? I would say that kind of works. Usually at if you're married, between married couples, owning properly jointly is very effective. Most often, I don't necessarily probate an estate until the passing of the last person. If there's the survivor, if there's one person, usually the surviving spouse gets to inherit kind of everything from their spouse. And that's only if you guys are on a house together. Both your names are on it. So in coming through this, always want to check on how title is held. Are you and your spouse both on joint bank accounts, or do you have a house together? And still, that works. That works usually just at the death of the first spouse. At the death of the second spouse, now when the kids are going to inherit, it can create joint title problems, or putting your kids on title and your stuff. I've come into court cases with that, because you're basically sharing or giving your kid an early inheritance, but now they own what you have and you have to ask them for permission. I've cleaned up so many title issues with people, or boyfriend and girlfriends owning property together, that then can't agree to sell a house. This has created a big title issue. And actually, I'm doing some really big litigation right now over a mother and a son. A mother just sued a son over a house that she kind of tried to give to her son, but then she took it back because it wasn't neither here nor there. But the joint title issues I see are just, it's probably okay between a married couple, but there's so many other steps beyond that. But if you start to share with anybody else, even your children, this can cause a bunch of problems. And I'd hope that you designate your beneficiaries. There's certain accounts, like for your retirement accounts. And James probably knows more about this than I, because I tell people, hey, go check your beneficiaries on your life insurance, on your retirement accounts, because those things are going to pass by contract. Those are larger institutions, and they don't necessarily go through probate, but whoever you have passed, like designated as your beneficiary, it's going to go right out to that person. But still, we see that with those designating your beneficiaries, because it goes out right to the person, it can go to minor children. It can go, and sometimes it's really hard to make fractionalized interests or something. If you want it to be spread to charities or something, it's probably not going to happen. So you can sign a will, but the will is not going to avoid probate. Or even if you do have a trust, relying on this, like usually there's a trust schedule. It's in the back. That's how it happened with, like, the one story, this guy who paid $3,000 for a trust, and there was assets that weren't put into the trust. There's usually a schedule on the back that says what's in the trust. Because you're buying and selling property and you're moving it along, it isn't a definitive answer of really what's in the trust and if you've really avoided probate. So there's really only one foolproof way to avoid court: a fully funded living trust with disability provisions. I say disability provisions because even if your children do develop, what did James say? He was talking about one of the most overlooked pieces of insurance was long-term disability or long-term care. Well, there's long-term care. There's also disability insurance. Because I think it's like maybe probably a quarter of the people during our lifetimes we're going to become disabled at some point. We're going to be bodies somehow don't function as well as we think that they do as we would like them, imagine them to. But in order to get SSI and Social Security benefits, if a person inherits a ton of money, that can put them over an income qualification to even get the Social Security or disability benefits that they need. So sometimes, even if you get just off the rack online will or anything, it doesn't say anything about, hey, if my heir or child has a disability, hold this money in trust for them if they have a disability. And I put in all my trust now, the disability provisions, to create a special needs trust. So it doesn't play with your kids' government benefits should they need them. So here, if we're going to have a fully funded trust, and we're going to retitle investment accounts. We're going to transfer stock and bond certificates into the trust. We're going to sign in new cards at the bank. You're going to create a new bank account for the trust, and you can buy all your groceries out of it. You just have to, that bank account cannot be in your name. And you're going to sign all your personal property, execute deeds to transfer your property to your trust. And then you're going to change your life insurance and retirement accounts and beneficiary designations. And so some people already have trusts. This is the number one way trusts fail, is for not being funded. And so many estate planning attorneys out there are not doing it. And if you're getting it on your plans on the internet, I guarantee you this is this provision here. I've had another guy, he came in, his wife, he was just trying to get his house. I remember that one. Yeah. Okay. He made his wife sign, he tried to sign a will that he got online. He didn't fill it out correctly, but also because of it, yeah, the kids were about to get inherited, but he almost didn't check the title. He didn't check in how it was titled, and his wife had already given half the interest. So he didn't check the title. She forgot. It's funny how often so many people forget how their property is held, and it's so important. So when you create a trust, you get to choose how to distribute your assets to the heirs. And they don't have to just receive the assets at 18, but instead you can schedule, you can schedule it out when, oh, they get this distribution when they're 25. They can get this distribution when they're 30. And then maybe the trustee was going to tell them that they can have this much money to go ahead and buy a house, or they can have an incentive to go to college. So all those are really great, but there's even better ways, because how many of you would like to own assets that can never be touched by creditors and will never be subject to estate taxes and can never be taken away in the event of a divorce? Yes, of course, we'd all like that. Now, what if I say, hey, we could do this for you? There are strategies that can work to actually protect your assets in a trust. But this is something that you can't quite do for yourself. This is something that you can do for your children. And these are a special type of trusts that I've been working on with some of my colleagues of a network group that I'm with. And there are these strategies out there, but so in the base form, having a fully funded trust it's gonna accomplish what you want, and it does work, and it doesn't cost a lot. I mean, I typically charge fees between $2,000 to $8,000, and it's gonna be based on what a lot of people what they want and how much work they're kind of willing to do. So what about estate taxes? What you don't know can cost your family big. Now, for many of you, a lot of people are worried about estate taxes, but in all honesty, it actually doesn't affect a lot of people. So at the federal level, I think President Trump did increase the federal estate tax from $5 million exemption to like 11.25 per person. So what that means is if you have, I think he just did that in 2018. Who knows what's going to happen in the new administration? We'll be saying, but it's very likely to probably stay the same. But if you have less than 11.25 million, and that's even per person, if you're married, you can actually have like closer to like 22 million. If you have less than 22 million, if you're a married couple, or about 11 million for a single person, you're not going to pay estate tax. The one issue is that we do live in the state of Oregon. Oregon is one of like the 20 or so states that have their own estate tax at the state level. And Oregon, I think, is probably, it has the lowest threshold that I've seen. It just 1 million. At just anything that you have in Oregon over $1 million, Oregon estate tax to Oregon state is going to start to kick in. And it's a sliding scale that starts at about 10%. And the more money that you have over the million, it can max out around 16%. So sometimes it's not huge, but I think that it's important for many people to know of. And even if you are a married couple and you have assets of about 2 million or 1.5, anything over the million, we sometimes use trust to help people get retain their tax exemption. So between a married couple, if your wife passes away, and you have 1.5 million, you want your wife to get her tax exemption at the time of her death of the 1 million. And then when you pass away, there's probably going to be, you're still you got her exemption, you're still kind of holding on to your surviving spouse's money. It's still yours, but you don't want to get taxed even at when your spouse passes away, because if you have over 2 million, you guarantee that you're going to have to use your spouse's tax exemption of 1 million to start preserving, and you've effectively inherited it from your spouse. So
Hey,
go
hey
ahead.
Milan, sorry, we had a question pop up. When you talk about estate taxes, what's included in that? Is it just assets and real property, or is life insurance also included in that estate taxation?
So yes, I think the and this is good because we've been working on this with James, is that it really is your gross estate, how big it all is, everything. And then from there, you're going to start to take away whatever, if you have to pay things, the creditors come off that, of course. There's going to be a lot of, it's like getting your deductions. But yes, life insurance is included in that number. And that's why there's this other thing. James is a big fan of it. So am I, of the irrevocable life insurance trusts. And this is another strategy to get those life insurance proceeds out of your own name so they aren't counted towards your own your estate, at least for Oregon's terms. So I'm going to say that the life insurance, the irrevocable life insurance trusts, are probably very advanced estate planning. I always like, it's there, it's good, you should be thinking about, but I always want people to at least get the base layer of their plans done first before they start thinking about this level of planning. It is there, but sometimes people get so tripped up on all the things that we have to do, because it's going to be its own separate thing, because it's another way, filing crummy letters and other things to get these things set up. Another kind of interesting thing about what's going to apply for your Oregon estate tax, and this is going to be, I think it's always important to have a trust if you have real estate in multiple states, because you would have to open up probate in each of those states. And so having a trust to hold it across multiple states, if you have property in California, or you have property in Idaho, or up in Washington somewhere, maybe down in Texas, who knows, you probably really want to trust just to avoid that, because opening up probate in all the states is going to be a problem. But also then, if you have property in multiple states, I believe that this is going to be something that you can probably, work on it for what counts towards your taxable estate. And this is something I'd really have to, say, well, I work with accountants on doing this, but it typically is where you pass away and where your property is. So for your real estate that's in Oregon is going to count towards your $1 million exemption in Oregon. But if you have real estate in another state that doesn't have an estate tax, Oregon probably can't tax that. What is more of a question is some things like cash, or in a bank account, and where does that bank account exist? Because if it's in a big national branch, is it going to be here or there? I mean, does it count as being in Oregon? Yeah. So there's where sometimes for those things that are movable assets, like maybe where your bank is, that stuff is probably going to more depend on where you passed away. So that's kind of just, I'm scratching at the surface of a very complicated problem, but it's very good to be aware of. But I'll say that I think that's a sufficient enough answer for now. I'll move on to the next slide, because we still got a lot more to cover. So here, and now when I talked about, we don't know, when the kids don't know when their parents' assets are, where they are, how much do their parents have and own, what's their parents' net worth. Right now in Oregon, I think this number is actually higher than this. I think my assistant Ethan, he looked it up again, and since the slide, it was probably around 500 million. It actually went up by about 80 million. But so this is a low number. At least $420 million is sitting in Oregon state, lost in unclaimed property. And that is mostly about $50 million a year goes to the state of Oregon and lost in unclaimed property. You're like, wow, it's a lot, but why is it going to the state of Oregon? Because so often the kids do not know what their parents own. And so I always tell them, they say, well, how do I figure it out? I said, well, go check out the house where your parents had. Hopefully they have a binder or a drawer where they keep all their financial stuff. Start going through it. Let's go track down if you see any bank statements in there. Let's read these things. And I say, if you guys don't do it, if you guys, it's too much for you, take them down to James. He'll take you, he'll take a look at the financial statements. Take them into me. We'll take a look, and we're going to hunt down everything that your parents had there. But every time I do go through probate or something, I don't know what we missed. We got most of it. We got the house. We got a big bank account. Maybe my clients have now inherited a couple $100,000, and they're pretty happy. They're pretty happy, but there could be 10,000. There could be 50,000. There could be a $200,000 undeveloped piece of land that their parent bought years ago and just forgot about this undeveloped land out but near Bend. That we didn't even know, but doesn't matter. My clients got their inheritance and they say, yeah, I did pretty good. But just to say $50 million a year goes to the state of Oregon and lost unclaimed property, because so often when people do estate plans, they don't do an asset inventory. They don't. And that's so much of when you do a family wealth planning session with me. In fact, James is also, I think he's got these little booklets in his office of you trying to list out all your assets. And some of what, and I have the same kind of questionnaire when you come in and talk with me. It's good for, I've had some people come in, they fill it out, and I add it all up for them. And I say, well, hey, I just wanted to say, did you guys know you're millionaires? And they said, no, I didn't know that. It's an interesting exercise when we do these asset inventory forms, because some people really don't know that they've been scrimping and saving their whole lives and what they've accomplished. But then the next part, I take that list and I have my assistant Ethan, we put it onto the spreadsheet so you can see it, everything that's on there, where it is, how much is estimated to be. And we tuck that into the estate plan so that if your kids ever find this trust, that they also see, oh, wait, oh, that's where that is. Oh, that's where that is. Oh, that's where that is. And we don't have to go play private eye or maybe even go on a wild goose chase. So this is so important. These just critical little things of just getting more financially organized so somebody else can retrace your steps and figure out what you owned. And then I've talked a lot about how a person passes your money down. I've talked a lot about money. James probably talks a lot about money too. But if you had to choose between the people you love receiving your money or your values, insights, stories, and experience, what would you choose? Most people, if they had to choose, they would choose their non-monetary assets, their intellectual, spiritual, and human capital. And so it makes no sense that most estate plans completely ignore that altogether. So I had another client that she had a voice message on her phone from her dad. And it just was, hey, honey, it's your dad. Just wanted to tell you I love you. I'll talk to you soon. Bye. And that's probably all the message said. But when her dad passed away, that was the only voice recording she had of him. And so I think she had it for about 4 or 5 years. And she kept that phone. And every time, and it's funny because every year, everybody's getting a new phone. But that voice message, she kept it just so that whenever she got stressed, whenever she got worried about the way things were going, she would listen to her dad. She would just put him on real quick. And so there's a few things to the way, I've changed the way I do estate plans to do an interview at the end to make sure that the voice message is there. So the people that you know just can hear, at least just hear your voice and hopefully tell some good stories. I know. Well, my old man, my dad, I'm making him do one now, but he's been reluctant. But it's been coming for a couple months now. I'm that close to getting it done. But there's so many one size fits all plans leaves your family at risk. There's so many people that there are a lot of attorneys, and some people like their attorneys, but I don't think they do enough time of, hey, I like you, can you do a will? Yeah, sure, I can do a will. And they get something, and it's because there isn't, it's almost like that would probably be the same level of work if you went on LegalZoom and got an estate plan. It's there, maybe you have it, but sometimes it just creates this false sense of confidence, that you can either do it DIY online or with a cheap lawyer. It leaves holes in your planning and your family with a big mess. I think I was just reading that Larry King, with the talk show host, he just passed away. And he had a handwritten will, handwritten to his kids. And oh my goodness, I already know how big of a mess that's going to make. Because he probably had other trusts, but even for the fact that he wrote this hand will means he didn't go back to his attorneys. He could have afforded any attorney in the world. He could have gotten any attorney he wanted. He probably did have trust, but there was a lot, probably around, it's estimated to be about $2 million that he did not fund into the trust. And it's going to go through probate, and we're all going to be able to read it online. So there's just all these, he was doing it DIY. He was just kind of writing it on a napkin. So too often it doesn't keep your assets out of court or the Department of Unclaimed Property in the event of your incapacity, death, and doesn't protect your inheritance. And also can leave your kids at risk of being in the care of strangers or somebody you would not want if you have not appointed guardians for your young children. And typically, it only addresses financial assets, not what matters most to you. So, how do we get started? The family wealth planning session. So, during that session, even before you come in, I have everybody fill out a family wealth planning asset inventory. And what this is going to do is going to get you more financially organized than you've ever been before. And it keeps your family out of the Department of Unclaimed Property. I mean, even if you don't want to do a plan with me, filling that thing out, and you probably are like, oh, wow, that's everything I have. You probably have never had it done before because some people file their taxes. I say, hey, do you have an accountant? Most of the time when they say that they have an accountant, it really means that they got a tax preparer. But the tax preparer is really only going to file your taxes based on what your income is that year, not based on everything that you have. They're not going to take a look at your net worth. So just having it, even just having done the homework, even before you come in, that right there is doing so much just to get yourself financially organized. And you're going to be able to make more informed, empowered choices. So you get to choose your planning level and the options and fee for your plan. We have 3 levels of planning, and they typically cost anywhere between $2,000 to $8,000 as a range. All flat fees, all agreed to in advance, no surprises. So whenever I quote you the fee, and you can talk about what you feel comfortable doing for yourself, that's the fee. That's it. And you get to know with certainty that your family will be expertly guided with love throughout your life and in the event of your incapacity. I also recommend coming back about maybe taking a look at it about every 3 years. And if nothing else, at least updating the asset schedule, because you're still alive, you're buying and selling property, and that's still important to make sure that that asset schedule is there and that everything's funded in the trust. So here, let's make it easy for you. I wanted to give you a certificate for a family wealth planning planning wealth family session, valued at around $750. And this is about 2 hours with me. If you do your homework, that this asset schedule. And then our gift 2 is going to be a certificate for $250 off your trust or wealth plan when you make an appointment. And then of course, this is James Monroe. He's offering $1,000 for a consultation with him. And so with that, You can, are there any other questions?
Thank you, Milan. No other questions that popped up. But can you touch on briefly? I know that when we've worked on plans together, and I know that when we set up my estate plan, we had named a what we called a financial manager to it. So it was the person who legally in the trust, if something happened to my wife and I, they're named in the trust, can say, hey, and take the trust to them and go, help, and walk through that process. And I know some of the plans that you and I have worked on, we've done that also. But can you touch on briefly in just a couple minutes about what we've called the trust protector, or the financial manager behind that, and how we've worked together on creating some of that for our clients collectively?
So when you create a trust, there's going to be pretty much 3 hats you're going to be wearing. You're like, can be the trustor. It's the person that is going to be giving the money into the trust. So you are that. You created it, you gave money into it. Then there's the trustee. They're going to be managing that trust. They're working for the trust. And then there's the beneficiary, the person that receives the benefit of the trust. They can get any money from it. So when we call these living trusts, some people are like, well, what's the living part of it? The living part of it is that during your lifetime, if you set up a trust, you are all 3 of those hats. You've transferred all of your property into there. And as I say, you can have your bank account in there and pay for your groceries with it. You buy your groceries right out of your trust account. It is your account. And for IRS says that, they understand that, yeah, that's you. For your lifetime, that trust is you. It uses the same social security number when you're filing your taxes. It's not kind of like a company where it can be taxed differently. We don't have to worry about flow through taxation or anything, or at EINs, at least until the trust is revocable. So during your lifetime, the trust is you, and you can revoke it. You can rip it up. You can change it. You can do whatever you want. When you pass away, typically these are triggering events that can make the trust irrevocable. Now all of a sudden you're not around. It's usually, sometimes we can have it on the death of the first spouse. Sometimes we can have it just on the death of the second spouse, that the trust becomes irrevocable. But when that happens, or if you're incapacitated, we usually have a backup trustee, somebody else that's going to be managing the money. So most people, if they're trying to do won't know what to do. If they're doing it online themselves, they're going to be naming their kids as a trustee, which isn't sometimes always necessary, because their kids are pretty much always named as the beneficiary. They're going to be receiving the money. But sometimes you want maybe somebody who can professionally manage that money for you. So there are professional bank trustees that can do it, and they do, because they have that money under management. They can have that. Hopefully they're making money for the trust. They're earning their keep, and at least earning 3% or more, because their professional trustee can earn 1 to 2%. And this is kind of like what we'd say custom, because we could get in and say, well, I don't want the trustee to earn any money. That means you're not going to have a professional trustee. But they're typically written that there's reasonable fees for the trustee. And even then, so something that James and I have been working on is that sometimes we do want that money to be managed by one of the kids or somebody else, that's a friend, but maybe they don't know much about money, but it's somebody that you just trust them to do the job because they're trustee. Trust is a big part of it. But then instead of having these big professional money managers be the trustees, that sometimes it's okay if your money is already being managed by, say, James, for instance, that we can put provisions in the trust that says that there is a preference that James is around, or his firm, to be able to manage that money. And so you can pick those preferences and put them in there. And then with the trust protector, that would be if there is no trustee, that a trust protector could pick another one, because sometimes if you name an individual as your trustee, they can pass away as too. They're mortal. So usually good to pick somebody young that might be around and want to do that job when the time comes. It's easier naming bigger institutions, but even then, some banks have actually gone under. And I've had a couple times where big banks that we've named in trusts weren't there 10, 20 years later. What is it? Banner Bank has changed so much. I think it used to be Premier West. So sometimes even an institution, they're merging, they're going bankrupt, they're morphing into other things, they're changing their names. So it's always good that you can get this fine level of detail in who you want managing your money. That answers the question.